Good morning, good afternoon. It is a great pleasure to welcome all of you to the online conference, Courts and Global Norms on Freedom of Expression. The conference is hosted by the World Leaders Forum and Colombia Global Freedom of Expression, an initiative founded in 2014 by President Lee C. Bollinger that seeks to advance understanding of international norms, institutions, and jurisprudence that protect freedom of expression and free flow of information. President Bollinger will open the conference, followed by two sessions with a 10-minute break between them. The first session, moderated by Dr. Dana Schmalz from the Max Planck Institute for Comparative Public Law and International Law, will address the application of international legal standards and comparative law practices in deciding upon freedom of expression cases. The second session, moderated by Professor Rubio Marin of the University of Sevilla, will be about the challenges for judicial protection of freedom of expression in the digital sphere. The conference will be closed by final remarks from Catalina Botero from Colombia Global Freedom of Expression Initiative. Please join me now in hearing some words from Lee C. Bollinger. Bollinger became Colombia's 19th president in 2002 and is the longest-serving Ivy League president. He's Colombia's first Sed Law professor of the university, a member of the law school faculty, and one of the nation's foremost First Amendment scholars. President Bollinger is also a member of the Pulitzer Prize Board and a co-founder of the Knight First Amendment Institute at Columbia University, a center devoted to defending speech and press freedoms in the digital age through litigation, scholarship, and public education. Thank you.
I would like to welcome you to this World Leaders Forum event, co-sponsored by Colombia Global Freedom of Expression. And I'd like to begin by thanking the honorable justices who are here today from courts across Africa, the Americas, Asia, and Europe. I'd also like to thank our moderators. And I'm grateful to the teams of the World Leaders Forum and Colombia Global Freedom of Expression, particularly Catalina Botero, for their work in organizing this conference. Finally, I'd like to express my gratitude to UNESCO for all the work it's done in partnering with Colombia Global Freedom of Expression and in supporting this event. It's a great pleasure to join you for what I believe will be a series of illuminating conversations among prominent judges serving in domestic, regional, and international human rights courts. Before we begin, I'd like to give you a little background on the co-sponsor of this event, Colombia Global Freedom of Expression. I established this project in 2014 to bring together experts and activists with faculty and students to advance understanding of international norms that protect freedom of expression and the free flow of information. I appointed Agnès Calamard, who recently joined Amnesty International to serve as Secretary General. The project was founded with a mission to foster dialogue among domestic, regional, and international courts responsible for protecting freedom of expression. It seeks to achieve this mutually enriching exchange through different projects. So in 2015, the initiative introduced the Global Freedom of Expression Prizes, which recognize judicial decisions and legal services that strengthen international free expression. Colombia Global Freedom of Expression has also created the Global Database of Freedom of Expression case law to survey, examine, and to compare noteworthy cases and identify global or regional trends. The database now hosts 1,644 decisions from 131 countries. Last year, Agnès Calamard and I co-edited the book, Regardless of Frontiers. The book brings together experts from different fields to to analyze how global norms on freedom of expression and information have been established, the actors and institutions that have contributed to their development, and the challenges they face. In keeping with its mission, Colombia Global Freedom of Expression is hosting this conference featuring conversations among justices from high courts and international human rights courts. High courts and international courts are critically important institutions responsible for defining the scope and the exercise of free expression and imposing limits on political power when it arbitrarily threatens those rights. They also play an important role in creating, interpreting, and applying global norms, which are created by international legal standards and comparative law practices, and can help guard against regressive trends. In the first session, we will hear from 4 respected judges as they offer their views on the role global norms have played in issuing decisions in cases involving freedom of speech. The second will focus on the challenges of protecting freedom of expression in the digital sphere. Please join me now in thanking our distinguished guests for being here with us today to share their thoughts and experiences on issues that are urgent, complicated, and of course, enormously consequential. With that, please welcome the moderator for the first session, Dr. Dana Schmaltz from the Max Planck Institute for Comparative Public Law and International Law. Thank you.
Thank you very much, President Bollinger, and it's a great pleasure to be moderating this first panel today, the panel on the application of international legal standards and comparative law practices in deciding upon freedom of expression cases. Now, freedom of expression is a fundamental freedom. It is important as an individual freedom, and it has an important collective dimension. This year's Nobel Peace Prize was actually awarded to 2 journalists, Maria Ressa and Dmitry Muratov, for their efforts to safeguard freedom of expression, journalists working in the Philippines and in Russia, respectively. But freedom of expression also finds limits in those cases where it might threaten the protected interests of other individuals. So courts, when deciding on freedom of expression cases, often face those difficult questions of balancing, of deciding interpretation. So today, we also have a global sphere of deliberation. Many of those freedom of expression cases take place before a global horizon. And we will hear in this first panel today from judges and justices of high courts and Supreme Courts who are experienced in deciding on freedom of expression cases and in deciding in a global conversation. So it's my pleasure to introduce to you now the esteemed panelists, and we will then enter the presentations one after the other. We will be starting with Judge Stella Anukam, judge at the African Court of Human and People Rights. Judge Anukam is a graduate from the University of Ife, Oyo State, Nigeria. She's a member of many professional bodies, a chartered arbitrator, chartered secretary and administrator, certified negotiator, and she has over 34 years of professional legal experience in public service with an expertise in international law and human rights. Then we have Justice Stephen Breyer from the US Supreme Court. He is a graduate of Stanford, Oxford, and Harvard Law School and has taught law for many years as a professor at Harvard Law School and at the Kennedy School of Government. He was a judge at the United States Court of Appeals for the First Circuit, and in 1994 was appointed as Supreme Court Justice by President Clinton. He has written several books and articles about administrative law, economic regulation, and constitutional law, and I'll just mention a few of his books, which include Active Liberty, Making Our Democracy Work, A Judge's View, The Court and the World, and most recently, The Authority of the Court and the Perils of Politics. Then we will be moving to Justice Chandrachud, a Supreme Court Justice from the Supreme Court of India. Justice Chandrachud was previously a Chief Justice of the Allahabad High Court and a judge of the Bombay High Court. He graduated from St. Stephen's College, Delhi, from Delhi University and Harvard Law School, was admitted to the Bombay Bar before then becoming a judge of the Indian Supreme Court. Then we will have Judge Farah McGregor, judge at the Inter-American Court of Human Rights. He graduated from the Autonomous University of Baja California and earned his Dr. Juris at the University of Navarra, Spain, with a specialization in human rights. He held different positions at Mexico's Supreme Court of Justice and was Executive Secretary of the Drafting Commission for the Code of Judicial Ethics of the Federal Judiciary and representative of the Supreme Court of Justice of the Nation before the Venice Commission. He first served as an ad hoc judge in the Inter-American Court of Human Rights, and then in 2013 was elected judge of the Inter-American Court of Human Rights. And then last but not least, we will have Danila Salazar Marin, the Vice President of the Constitutional Court of Ecuador. She's a law professor at the Universidad San Francisco de Quito, where she served as Vice Dean and co-director of the Legal Clinic. She worked as a human rights specialist at the Inter-American Commission on Human Rights and holds law degrees from the Universidad San Francisco de Quito and also from Columbia University. So without further ado, I'll give the floor to our first panelist, Judge Stella Anukam. You have the floor.
Thank you very much. I have the screen. Thank you, moderator, and thank you, distinguished panelists and audience. It's my pleasure to be here this afternoon, and greetings from the African Court on Human and People's Rights. This presentation, which is an online presentation in an online conference, is presented by me in the capacity of being a judge in the African Court on Human Rights, where I was elected and took up responsibility there in 2018. The context. The context of this presentation will be first to give you a background history of the court. The African Court on Human and People's Rights is established in 1998 Ouagadougou Protocol, which came into force in 2004. Officially, operations began in 2006, while then the court was in Addis Ababa, Ethiopia, before the relocation to the present seat of the court in Arusha, Tanzania. The first judgment by the court, the first judgment on merit by the court was delivered June 2018, and that case is the famous case of Tanganyika Law Society, Reverend Christopher Mitakila versus Tanzania. Although in that particular case, the focus was on the rights of discrimination, freedom of discrimination, not expression. However, the jurisdiction of the court is unique because by virtue of Article 3 of the court, of the protocol establishing the court, the jurisdiction of the court extends to cases and disputes concerning the interpretation and application of the African Charter on Human and People's Rights, as well as the protocol and any other relevant human rights instrument ratified by the states concerned. So indeed, our jurisdiction is very wide. Like other international tribunals, the court applies the admissibility criteria pursuant to Article 56 of the Charter, whereby we are expected to ensure that the identity of the complainant, of the applicant is known amongst others, and then the issue of admissibility of application being brought after local remedies or domestic remedies have been exhausted, as well as the application being brought within a reasonable time, among so many other criteria. Individuals and NGOs have access to the court only where, by virtue of Article 34.6 and Article 53.5.3 of the protocol, only in instances where the respondent state, the state, have made a declaration. So in our case, apart from ratifying the protocol establishing the court by member states, they are further expected to make a declaration that gives access to the court by individuals and NGOs that have a recognition before the African Commission on Human and People's Rights. Permit me to also speak about the African Commission on Human and People's Rights, popularly called the Banjo Commission. Indeed, the African Charter on Human and People's Rights establishes the African Commission on Human and People's Rights. So that commission has been in existence as far back as when the Charter itself was promulgated. And there's the kind of relationship the commission has with the court, which is that of complementarity. And in between both institutions in the continent, we can receive cases from one another, and we can also receive and refer cases to or applications to one another for determination. The functions of the commission includes the promotion of human rights and protection of human rights, just like the court. And its mandate is categorized as being promotional and protective. And the promotional activities include appointment of special rapporteurs. So you can have, for example, a special rapporteur on freedom of expression in the commission. And then they also conduct country visits, studies, researches on African problems in the field of human and people's rights. They organize seminars on human rights issues and make recommendations to governments. It is a quasi-judicial body, because even though they hear complaints by way of communication, they can only give persuasive opinion. Their decisions are not enforceable. And then the African Charter itself, which establishes the African Commission on Human and People's Rights, has been ratified by the 54 countries in the continent, except Morocco. Morocco recently joined the Union, and it is yet to ratify the African Charter on Human and People's Rights. Now, I go directly now to the subject matter for our meeting, for our consideration and the conference this afternoon, which is the freedom of expression vis-a-vis the African courts. Article 9 of the Charter is very key in this respect. Article 9 allows every individual right to receive information. And also Article 9(2) also provides for the right to express and disseminate their opinion within the law. Within the law is that phrase within the law is a very contentious one, which I pray I will have time to allude to when I begin to look at some of our decided cases. For litigants before the court, Article 3(1) of the protocol establishing the court creates room to plead other relevant human rights instruments ratified by the state concerned. For example, we find situations like common to these three cases I'm going to talk about, where references, where the ECOWAS treaty, the revised ECOWAS treaty was pleaded as concerning freedom of expression, and together with the International Covenant on Civil and Political Rights. By the way, the ECOWAS means Economic Community of West African States. It's like a sub-regional body for West African states in Africa. So thus far, we have three key judgments. Unfortunately, the situation is still the same as at today, even though these judgments were given as far back as 2016. These are the three key judgments in the area of freedom of expression, namely the Nobel Zongo and others versus Burkina Faso. It's a 2014 case, and it is reported in the African Court Law Reports volume 1. You find it at page 219. And the second case is the Loher Issa Connected case, also against Burkina Faso. It's also reported in our law report, volume 1. And the third case I will be talking about is the Igabire Victoria Umuhaza case. This is versus Rwanda. It's also reported in our law report, volume 1. Now we'll talk about the first case, which is popularly called the Zongo case. In 1998, Norbert Zongo, an investigation journalist, and 3 of his companions were found burnt in a car in the outskirts of the capital city of Burkina Faso, Ouagadougou. It is believed that these murders had to do with a report due to be published by Mr. Zongo, in which he was to expose wrongdoings, especially corruption, involving the brother of the then president of Burkina Faso. For about a decade, precisely 7 years, 8 months, and some few days, this case lingered on at the domestic level. The pace was rather slow. At a time, the case was frozen, but suffice to say that the case prolonged for a very long time. And the importance of that prolonged proceeding at the domestic court will come to light when we are considering admissibility, because it's one of the ground Article 56 of the Charter provides for in terms of considering whether an application will be admitted, is admissible or not. Maybe I should just talk about that. In the African courts, as I earlier said, Article 56 gives us grounds to consider whether to accept an application or not. And one of them is this issue of exhaustion of local remedy. And we know, and the court has established over time that we would hold that local remedy is not available, is not enforced where it is not available. That is where there's a violation, and at the domestic level, there's no remedy, no process to remedy the violation. There's no legal process for the remedy or to redress such violation. And also, where there is a remedy or a redress system, it is not effective. It is not sufficient and is unduly prolonged, like in the case of Zongo. In that case, we hold that actually there's no remedy. In the case before the African court, the applicants, back to this case of Zongo, the applicants alleged violation of these rights. Article 1 of the Charter, which has to do with respect for human rights, and Article 7.1, which has to do with the right to have one cause heard before a competent national court, and the right to equal protection of the law and equality before the law. And then Article 9, as well as Article 66(2) sub C of the ECOWAS Treaty, and Article 9(2) of the ICCPR, which all are on the protection of journalists, and Article 4 on the right to life. So these were the allegations by the applicant in his claim for remedy of these violations of these articles. Now, what did the court find? After an extensive deliberation, the court found that Burkina Faso failed. And before I talk about the court finding, it's important to note that in this case, Burkina Faso, being the respondent state, actually submitted their defense, and it participated actively in the hearing of this case, even in the public hearing. So here, the court haven't had both parties found that Burkina Faso failed to diligently investigate the killing of Zongo with a view to finding its killers and bringing them to justice, indeed. And that Burkina Faso had a duty to provide remedies where there is a human rights violation. So though there was an investigation, indeed the state set up a commission to investigate, but they were not diligent. The court found that they didn't do so diligently. And then the second finding of the court is that the notion of victims must not necessarily be limited to that of heirs and can include other relatives who can be considered as having suffered moral damages. If you recall, while talking about the facts of this case, we recall that Zongo and his colleagues, they were already dead. So this case was brought by the relatives of the victims. And the court also heard that failure to investigate Zongo's murder could cause journalists to work in fear. Applicants had failed, but however, the applicant had failed to prove that the Burkinabe media was restricted as a result. The court found that the respondent could not be guilty of violating the journalist's freedom of expression simply for failure to investigate the murder.
Excuse me, Honorable Judge Anukam, I'm very sorry, the time is already at a close, so maybe you could come to a conclusion.
Yes, I'll go to, can I go to the, how many minutes, ma'am?
The time is up for the presentation, but if you want to take 1 more minute to conclude or give it, we'll have more time in the question and answers later.
Okay, thank you. Let me just go to the concluding remarks, if you don't mind. Yeah.
That would be good, great.
Yes, concluding remarks then, because of time. The court and commission's jurisprudence has been consistent in vindicating the freedom of expression for everyone and for journalists especially. There has been clear approach in assessing what may be restrictions on the freedom of expression in the African context, particularly in relation to Article 9 sub 2 of the charter that requires for that provides for a phrase within the law. The domestic utilization of the jurisprudence of the court and the commission is still limited. The court recently has been affected by withdrawals of Article 34.6, that is the declaration article. And then lastly, both the commission and the court, they suffer from implementation challenges. I thank you all for listening.
Thank you very much, Honorable Judge Anukam. And with that, we are coming to our next speaker, Justice Stephen Breyer from the United States Supreme Court. Justice Breyer, you have the floor.
Thank you very much, and good morning, good afternoon, wherever you are in this world. I think all of us and people listening to this have a strong belief that freedom of speech is an essential human right and democracy depends upon it. And of course, we should look at what each other is doing because that will be helpful. We'll learn lessons one way or the other. And the United States has had the First Amendment, which protects freedom of expression for about 230 years. And if we go back 230 years, we'll see it didn't protect very much. John Adams thought the Sedition Act was a very good idea, and the Sedition Act stopped people from saying things he didn't like. Well, there's been change, and a lot of change. But we still have problems. That's hardly surprising for judges. I mean, judges are always facing problems. So let me do this. Let me mention one way. Let me make a textual point, and I'll make a point about approach, and then I'll make a point. I'll tell you a problem that I think we're having now, and you have it to a degree, and maybe we can learn something here. The textual point is this: there's a difference between most of the constitutional or legal protections of human rights in the United States and elsewhere in the world. Why? Well, there's a good part and a bad part. I think the good part was in an article by Bert Newborn, who pointed out how this protection is written. Now, he said, listen to it. It's in the First Amendment. It starts, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. When that was written 230 years ago, Newborn says, It was about thought. Religion and thought were pretty much indistinguishable. And so really the founders were thinking of this, Mr. and Mrs. America, think what you like. Then it says, no, Congress cannot abridge the freedom of speech. See, after you think of something, you can say it. You don't have to say it. A lot of things are better not said, but if you want to say it, say it. Or abridging freedom of the press. Once you say it, you can communicate it to others. How? It's a big country, a lot of people. The press is necessary to do that. Or they cannot abridge the right of the people peaceably to assemble. Now, why is that there? Well, we now assemble, we're assembling right this minute. Because after our idea gets around, well, then we can talk about it together. And then you cannot abridge the right to petition the government for a redress of grievances. Now, you see what's there? Think about it, speak about it, transmit it to others, then talk about it with each other, then tell Congress. And that way, Congress will have an idea what people are thinking, and that way the legislature in a democracy will reflect what people want and think and are discussing. It fits together. All right, I think that's a good thing. Easy to teach. The students who have to learn it. Next point that isn't there, and this is a tough one. If you go look at the European Charter of Human Rights, what will you find? And you find this in lots of constitutions. They will have, yes, freedom of speech, but restriction is possible in the interest of national security, integrity, public safety, disorder or crime, protect health, protect morals, protect reputation of rights of others, prevent confidential disclosures, and maintain the authority and impartiality of the judiciary. We don't have that. Now, what it means in practice is when you're in a country, or say you're in Europe, there will have to be a balancing. Some people think that balancing is pretty good, as long as you remember free speech. And the balancing will be, is the harm that this government is working to free speech? Let's look at that interest. How much is it being hurt? And let's see what the justification is. And let's see if the justification for the harm to free speech is proportionate. If it's disproportionate, law says you can't do it. Otherwise, you can. No, we don't have that. And instead, we have what I think of sometimes as something like the tax code. And I will spare you the details. But it's sort of one rule after another. I don't think rules work too well here. We know what the point of free expression is, and you get right to the point, I think, with proportionality, which is what most countries use. But we pretend not to use it. I think we really do. All right, so that's a difference in text, and it's a difference in approach. Now, keeping that in mind, let me turn to the third, which I think is important, at least in the United States now. Obviously, as you have just heard, in Nigeria, in many other places, the basic need to protect freedom of speech is just that, a basic need. When somebody says something that's politically unpopular, you protect it. When somebody goes to jail because they don't like what he says, because he's advocating something the government doesn't like, you protect his right to say it. That's easy. It's easy some places, and it's not at all easy in other places. And that is a basic challenge. In the United States, it's probably easier because we have a long tradition. But, what do we do with this kind of problem? A problem that sometimes goes under the name of hate speech. If somebody says something really awful about, say, a minority group or some other group of people and stirs up hatred, what do? Well, we know he can't stir up violence. If it's going to lead to violence, you're out of luck, bad luck, freedom of speech, no freedom of speech. Don't do it, and you will be punished if you do. But what happens if it's not going to stir up violence, at least not immediately? It's just very unpleasant. And in the long run, it might contribute to dissension in the country. Well, there we have what Voltaire said. Voltaire, and we use this a lot in the schools, he said, I disapprove of what you say, but I will defend to the death your right to say it. By the way, Voltaire didn't actually say that. It was a woman who was his historian who actually created that phrase. And that's useful to know and very interesting. But the point's the phrase. And I cannot tell you how often I will have to say, and do say, to the students, because what we believe is not going to be carried on just by us. It's going to be carried on, it's got to be carried on by my children and my grandchildren. And so those are the generations we have to worry about. And I say, you know, freedom of speech is not there for people you like. If they're saying wonderful things, they don't need it. It's there for the people you don't like. Even that? Yeah, even that. Now, that's a lesson that has become harder and harder to teach. Because if you're really willing to put up with that, if you really believe it, there are going to be people going around saying really pretty bad things. Maybe they won't stir up violence, but there'll be things that we really disapprove of. So how much do we believe it? And how do we teach the next generation? And how do we teach them not to, in the classroom, censor the students, 14 years old, who are saying things they don't like? Now, you see, I think for the countries and the places that have a more developed system of protecting basic speech, that remains a big problem still. And there are no easy solutions. And in Europe, they do not allow hate speech. They're much more intolerant than we are in the United States. In the United States, we're more tolerant of it. Why? Because in the United States, we're afraid of giving somebody, including judges, the power to say what is hate speech and what is not. Because the person who has that power might decide to use it, even if he's a judge, to censor things he doesn't like. So we say, leave it alone, let them free. But are they free in the schools? Are they free in a lot of places in the United States to say things that are unpopular at the proper time and place and not leading to violence and so forth? Are they better off in European or other countries where there's greater control over that kind of hate speech? Does it lead to a more better functioning society? I see then, in other words, to summarize, two big problems. One is the kind of problem that you've heard well expressed from the judge from Nigeria. How do we get these very basic things, these unpopular political parties, these opposition parties, they're to be out there and not thrown into prison and have the right to say something? That is one big problem that will be agreed upon what should happen, but how you get it to happen is not so easy. And the second big problem, I think, practical problem, is where we are right now in the United States of teaching younger generations this First Amendment is part of a democratic government and is part of protecting people whose speech you don't like. And how far do we go there? And how do we do it? And how do we stop the censorship? I just mentioned those two problems. And I mention them because I do not have solutions. And I'd be very, very interested in anything else anyone wants to say about them. So there you have some differences of text, some differences of approach, but similar problems across many parts of the world and how we work on them, and particularly how we transmit what we think about them to children, to grandchildren, and to people who have to work in and solve the problems, including the democratic problems of this world so difficult that we have today. Those are some of the things that I will listen with great interest to what you say.
Thank you very much, Honorable Justice Breyer. And with that, we move to the next speaker, Justice Chandrachud of the High Court of India. You have the floor.
Thank you. Good afternoon and good morning and good evening. The Association of Free Speech and Democracy predates modern constitutions and international human rights norms. The classical Athenian democracy prided itself for being a protector of the freedom of speech. Plato noted that there was more freedom of speech in Athens than anywhere else in Greece. But Athens suffered many of the same flaws that modern democracies have to grapple with. More crucially, in the context of the freedom of speech, we can see that the Athenian commitment to free speech faltered when Socrates emerged as a proponent of unorthodox religious and political ideas, including his opposition to democracy, for which he was put on trial. During his trial, Socrates famously announced that if you offer to let me off this time on condition, I am not any longer to speak my mind. I should say to you, men of Athens, I shall obey the gods rather than you. Socrates was finally sentenced to death. The Athenian experience is emblematic of the moral coercion that societies typically exert on individuals to comply with expected norms of thought and conduct, which has been highlighted by John Stuart Mill in his seminal text on liberty. Mill argues that we need to protect the liberty of conscience, thought, and expression of the individual for them to resist these social forces and pursue their own course in life, as long as they do not harm or interfere with the life and liberty of others. Thus, it becomes the duty of the court to intervene when an individual is persecuted for speaking truth to power. One of the areas where political power is misused to clamp down on free speech is journalistic freedom. While such an exercise of power can be politically convenient, it deprives citizen decision makers of valuable feedback that sustains a democratic polity. The Inter-American Court of Human Rights has held that it is the duty of the state to protect a journalist from threats and harassment. Otherwise, it will adversely affect the ability of journalists to report freely. The African Court of Human Rights, in a case involving imprisonment of a journalist under a criminal defamation law, held that defamation can be criminalized only in certain cases, and imprisonment of the journalist violated the right to free speech. In two different judgments, the Constitutional Court of Ecuador has stepped in to protect free speech of the media. The court held that institutions and figures do not have the same degree of protection of reputation or honor that private citizens possess in a case brought by the government against a newspaper, exposing unreasonable expenditure of public money. In another judgment, it emphasized on the freedom of speech during elections. In a judgment authored by me, the Indian Supreme Court has recently upheld the freedom of media to report oral observations made by judges during court proceedings, where I observed that enabling a media to report court proceedings not only protects the rights of reporters, but is also a part of the process of augmenting the integrity of the judiciary and the cause of justice as a whole. Mill's individualistic account of liberty does not account for the systems of power within which speech is made. Social forces, culture, and institutional practices shape freedom, especially freedom of expression, in particular contexts, specific and in historically determined ways. The courts cannot turn a blind eye to the effect of their rulings on the political and social order. In a judgment which was authored by me, on the issue of satire and the prominent place of satire in our public lives, I said, satire is a literary genre where topical issues are held up to scorn by means of ridicule or irony. It is one of the most effective art forms, revealing the absurdities, hypocrisies, and contradictions in so much of life. It has the unique ability to quickly and clearly make a point and facilitate our understanding in ways that other forms of communication and expression do not. At the same time, free speech under the Indian Constitution is restricted by Article 19(2). The restraint on speech that demeans, stigmatizes, and incites prejudice against a vulnerable group of people also finds place in the Canadian and the South African constitutional model, regulating hate speech, the harmful speech that is being adjudicated before the court that becomes reflective of the wider environment of marginalization and discrimination that exists against certain groups and further feeds into such an environment. The German Constitutional Court has also held that prohibitions on hate speech in federal criminal law are legitimate restraints on free speech. The German court does not privilege free speech over other competing constitutional rights and interests. In such cases, a court is required to balance the competing interests of free speech and the right to equality and human dignity. However, free speech can often advance the cause of equality and human dignity when the court intervenes to protect the freedom of expression of vulnerable groups who often find themselves in a hostile social and political environment. For example, the Supreme Federal Court of Brazil stepped in to protect the freedom to publish LGBTQ plus content when it ruled that the actions of a mayor to ban a comic book showing a kiss between two male characters is illegal. The court held that targeting of LGBTQ plus content by public officials violated the freedom of expression and the right of equal protection to all. A bench of the Indian Supreme Court, of which I was a part, amongst other things, held that decency and morality, two of the grounds available to the state to restrict freedom of expression, do not justify the existence of a law that criminalizes same-sex sexual intercourse, because decency and morality cannot function as constitutional permissions for majoritarian government. The court further clarified that public displays of affection between members of the queer community are an extension of the freedom of expression. The Supreme Court of Colombia has recognized that the right to protest has constitutional and international protection, and that authorities are responsible to ward off, prevent, and punish systematic, violent, and arbitrary intervention of the public force in demonstrations and protests. Though there may be jurisprudential differences between how speech is protected and regulated in the different jurisdictions that we come from or which our courts oversee, the values and the principles governing freedom of expression have global currency. The strength of this transnational dialogue may not always be visible through explicit or expressed judicial acknowledgements. However, it often shines through the growing harmony in judicial voices across state boundaries. A transnational judicial dialogue can be useful in widening the scope of materials and practices that a domestic court can take inspiration from. There have been many instances where the Indian Supreme Court has drawn on comparative jurisprudence while adjudicating on constitutional issues involving free speech. American jurisprudence, for instance, was utilized by our Supreme Court recently when we struck down the provisions of Section 66A of the Information Technology Act of 2000, which made the publication of information through a computer resource or communication device, which was grossly offensive or menacing in character, caused annoyance, inconvenience, or obstruction. We relied upon the classical clear and present danger test enunciated by the American Supreme Court. Then in another case, we have clarified that customary international law that does not conflict with our municipal law would be deemed to be incorporated in the domestic law of India. Finally, we've also acknowledged that the approach adopted by the European Court of Human Rights in protecting freedom of expression is not different from that of Indian courts, though as Justice Breyer just mentioned a short while ago, they have an extensive list of circumstances for limiting freedom. There is no denying that comparative constitutionalism and international law are increasingly playing a role in constitutional adjudication by national courts, since issues of social and political emancipation transcend geographical and political boundaries. The march of this transnational judicial dialogue in an increasingly global world is inevitable. In fact, it is a welcome occurrence, since through our judgments, we are able to speak to the wider international community on constitutional principles, values, and aspirations, and learn from each other's experiences. Perhaps in the time of pandemic, we as judges realize that we are not isolated and alone in the work that we do. So in conclusion, I can only say this, that whether it is in the right of a woman to seek an abortion, or in the legal conflict over the refusal of a cake shop owner to serve a wedding cake to a person of the LGBTQ community, the freedom of expression is the foundation of our right to a life of dignity. In doing our bit to protect free speech, judges enhance the right to human dignity. The courts are, of course, not the only fora where a dialogue between national judges takes place. Judicial dialogue takes place in international conferences and seminars as well. Hence, the conference organized by the Columbia University has given me this opportunity to engage with my counterparts in other jurisdictions. I would once again like to thank the Columbia Global Freedom of Expression Initiative for inviting me to share some of my thoughts this evening. Thank you.
Thank you very much, Honorable Justice Chandrachud of the Supreme Court of India. And now hand over to Judge Farah McGregor of the Inter-American Court of Human Rights. You have the floor.
Thank you very much, Dana. It is a great pleasure and privilege for me to share this distinguished panel with fellow judges from the African Court of Human and People's Rights, the Supreme Court of the United States, the Supreme Court of India, and the Constitutional Court of Ecuador. First, I would like to thank Professor Lee C. Bollinger, President of Columbia University. In addition, I would like to express my gratitude to Professors Roberto Saba and Catalina Botero, Columbia Freedom of Expression Chair, who organized this important conference that gathers the voices of judges from regional human rights, supreme, and constitutional courts. In its more than 40 years of existence, the Inter-American Court has been a key actor in the sphere of freedom of expression. As a judge and former president, I would like to highlight some contributions of international standards on freedom of expression and try to summarize some of the regional trends on the matter. I will continue my presentation in Spanish. En general, la contribución del sistema interamericano.
In general, the contribution of the inter-American system is quite important when it comes to freedom of expression. Not only the court itself, but also the Inter-American Commission, which is a quasi-jurisdictional body that is in Washington, D.C., and also how it reports as to freedom of expression. Also the Inter-American Court, which is the jurisdictional body that is based in Costa Rica. The Inter-American Court initiated its jurisprudence in 1985 in a consultative opinion, or consultative union, which is one of its competencies when it comes to norms, not only to rule on some cases, but just to advise on certain norms. Costa Rica presented a case on the obligation of journalists to be collegiated. That was clear that freedom of speech, freedom of expression was the cornerstone of democracy. It was decided on the Inter-American Court. Since then, the Inter-American Court has interpreted Article 13 of the Inter-American Convention that regulates freedom of expression and thought, but also based on the Inter-American Charter and other treaties, other regional instruments, and also including a very enriching dialogue with other international courts and also domestic courts. Altogether, when we analyze this jurisprudence, the issues have been very diverse. Issues like access to information, film censorship, limits of criminal law, the relevance of the media as a vehicle of vehicles of freedom of expression, and also the illegitimate restrictions of on such. When it comes to running for election, the political opposition, issues related to the right to having to the truth, the rights of people to express themselves in their native tongue, the freedom for political opposition and journalists, including forced disappearance, protection of workers when it comes to relationships between private parties, issues such as informed consent, and more recently, there was an issue of gender-based violence against a journalist, a female journalist. There are around 30 cases or so, which had a tremendous impact in the region and which have led to normative changes and set jurisprudence, and also has changed public policy. I will try in the next few minutes just to focus on 4 fundamental aspects. Number 1, indirect restrictions. Number 2, corruption and freedom of expression. 3, protection for journalists, which unfortunately in Latin America, this is tremendously important. And number 4, issues that have to do with the independence of the judiciary in general and magistrates in certain contexts. Well, firstly, indirect restrictions. In some states where there is a democratic weakening or there is an institutional crisis, they use means that are apparently legitimate to restrict freedom of expression and to silence dissident voices and the opposition. These indirect restrictions have been broadly addressed by the court. The court has developed the concept of deviation of power, actions of the public policy that by the book they comply, but they have an motivation that will harm the freedom of expression. One case is Granieri et al. Against Caracas or Radio Caracas, because the government did not renew the license, the radio license of this TV station. The Inter-American Court considered that this was what we called a deviation of power that had an impact on freedom of expression, not only on the shareholders and the employees of the channel, but against the Venezuelan society as a whole, because there was a use of a power allowed by the state, which is to regulate the media with an illegitimate right, which is to align that media outlet with the government's opinion. Another emblematic case is San Miguel Sosa against Venezuela, which has to do with the reprisals suffered by people who signed the Tascon list, which is well known, that gathered signatures of those who supported a referendum to impeach the then President Hugo Chavez. For the court, once we established, there was a clear division of power because there was a clause in the contract as a pretext to cover the actual intention, which is to generate a reprisal against him because he had exercised political right, which was perceived by the high official as an act of political disloyalty. And then I will talk about freedom of expression. We can say that there is an interconnection between the rule of law and the development of such, and they reinforce each other. This is recognized by the goal of a sustainable development of the United Nations, which is about having more fair and inclusive societies. The court, and I will just talk very briefly. There's the case of Alvarez Ramos from 2019, when they determined that the penal code should not be used when it comes to the right to honor, personal honor. In 2013, this journalist published an article in a Venezuelan newspaper in which he was talking about alleged irregularities on of a public bank by a government official. This article led to a penal case against Alvarez Ramos, and the court considered and set precedent, a criminal case, when they pointed out that this punitive response through criminal law was not possible, especially in context as such, in order to protect the honor of public officials.
The third issue in the region that we need to take into account is protecting the standards, or the standards to protect journalists. The courts have pointed out the role of journalists, and they've decided to exercise the right to expression as their livelihood. So all journalists, and the court has said that journalists are subject who are vulnerable. Therefore, they require a reinforced protection when the state is aware that there is danger when they do their own job. However, there are many cases. I don't have enough time to discuss them all. There is the Peroso case and others where the court reviews a number of violent acts against a TV channel, and the court pointed the obligation that the court had to protect journalists, but also pointed that high public officials were making statements against journalists in Global Vision and then this exacerbated this intolerance and rejection by the population against them. Vélez Restrepo and Family Against Colombia, for example, is another case. There's a cameraman who was attacked by the members of the National Army after having filmed military attacking people who had participated in a public demonstration. More recently, we have the Carvajal case against Colombia, 2018, about the murder of a radio journalist who had been investigating alleged act of local corruption, as also alleged irregularities in the public administration relating to money laundering proceeds from drug trafficking. On 18th October this month, the Inter-American Case Court also has another case that's important, Bedoya Lima against Colombia, which is about a well-known journalist from Colombia, Ginette Bedoya, who's also a known activist, and she's known to defend the rights of female journalists. This is in 2000, Ms. Bedoya was kidnapped at the doors of the La Modelo jail by a paramilitary group. She was subject to abuse and violence, and she suffered verbal and physical and sexual violence. This is the first case in which the court acknowledge this type of attacks to female journalists, and the pandemic has been important because we have statistics and there's been an increase in attacks to female journalists. In this line, the court considered that the impact of this violence to society, they were different because the person who was attacked was a female journalist. We must mention that the court based itself on standards that go beyond the American Convention and used other standards, even using some of the words of the special rapporteur from the Inter-American Commission, because there is the existence of an exclusion of female participation in the public lives or in the media agenda. The court mentioned the importance of the need to have plurality in the media because, as the former relator of freedom of expression said earlier, who is also coordinating this seminar, Dr. Catalina Boctero, and let me quote her, she was also a witness for this case, to silence female journalists. And when you do, you silence the stories that are usually only told by women. So finally, I think this is an emblematic case, and it established means to not repeat and reparation, and also positive obligations such as to identify and investigate due diligence of the specific risks that are specific to female journalists. And because of that fact, also factors that increase the likelihood that they will become victims of violence. It also took a gender perspective when it would take steps to guarantee the safety of female journalists, among others. And very briefly now, because I think my time is running out.
Yes, if you could conclude, Honorable Judge, that would be excellent. The time is about to end.
Perfecto. Solamente
of course. Just to conclude, finally, we talk about the independent courts and the freedom of expression to the judiciary. There were some cases that are emblematic, and the court has established, in the case Lopez Lone, for example, there is a context where you break, where you have the judges have the right to defend democracy as part of their freedom of expression. I'll conclude, but first I'd like to say that this year's agenda includes two cases in the Inter-American Court, one on community indigenous radios, a case of the Mayan people, the Cachipel people, and Zupango against Guatemala. This is the first case of an indigenous community radio, and two, the El Universo newspaper versus Ecuador. Thank you very much.
Hello, Judge Farah McGregor. And with that, we are moving to our last speaker of the panel, Daniela Salazar Marin, the Vice President of the Constitutional Court of Ecuador. You have the floor.
Muchas gracias y buenos días.
Thank you very much. Good morning, good afternoon, or good evening. I would first like to greet all the members of this panel, those judges that have preceded me, Judge Chandrachud, Judge McGregor, Judge Anukam. I'm very honored to share this space with you, with all these judges of such importance. I'd also like to thank President Bollinger and Caterina Botero and for generously inviting me to this event. I would have loved to have this event in person, of course, so that I could come back and visit the Columbia University campus, but I must admit that this is a timely event in order to talk about the role of courts to protect the freedom of expression, particularly the way in which courts, when deciding these cases, use or do not use global standards on freedom of expression, some from international law and human rights law, and others from comparative law. The constitutional law of Ecuador often uses the case law from Inter-American law and also on comparative case law when we determine the breach of these rights, including the right of expression. Because the Constitution of Ecuador in 2008 respects the international law on human rights. It talks about the treaties and an international instrument many times. It is a mandate of the Constitution to use the treaties and international tools for human rights and incorporate them into the Constitution. And they are very, very privileged, and they can be directly applied by judges or public authorities in the country. Naturally, constitutional justice has also used the treaties, international treaties, or jurisprudence of human rights in order to protect rights. The right of freedom of expression, of course, is one of them. In these very few minutes that we have, I just want to share one case in which the Constitutional Court of Ecuador has used the standards of the Inter-American system and the comparative law to decide a case on freedom of expression. I will talk about the case as an example. I think the case was already mentioned by Judge Chandrachud. It's the decision on the Diario de una Hora. I'd like to briefly tell you the relevant facts of the case. There was an NGO which had its own monitoring as to how much public money had been spent on official advertising and showed the numbers to the press. So they went to a press conference and published a report saying that it was clearly numbers that were obtained by this organization based on its own monitoring as to how much the government was spending officially. Immediately, the government sent a letter to this newspaper saying these are false because I've gotten discounts. There were no proof as to these discounts, but it said these are the official numbers of public expenditure, and they're different from the ones that the newspaper had. So what did the newspaper do? They published the government's response. The government at the time was not particularly respectful of the freedom of expression, but the government came to the constitutional justice for a case, and it won in the first and second instance. The judges who heard the case decided that the government had the right to have true information, honor, and the right of the government to ratify, so they forced the media to publish an apology. And the case came to the to the Constitutional Court, where I work, and the Constitutional Court issued a decision revoking the previous decisions and holding the rights of the newspaper for the freedom of expression. Throughout the sentence, if you read it, you can see the impact of international global standards, such as the Inter-American Court, for example. It has been cited throughout the decision to clear that the state does not have inherent rights, so it cannot stipulate. It tried to explain the role of the media as a vehicle for expression and the dissemination of information. We cite the standard to determine that we have a specifically protected speech in order to explain the tolerance level for public authorities and to determine the right to reply and how does that relate to the freedom of expression. Particularly, it also decided on the right to have true information. I have very little time, so let me just talk about the last point, which I think illustrates something for this panel. For those who don't know the judicial system in Ecuador, I must say that one of its specific characteristics in the constitutional text of 2008 in Ecuador is that it's very detailed and almost like a rule. Our constitution does not limit itself, such as the US constitution mine, to abstract, but rather Article 18, number 1, when it protects the right, describes it as the right to look for, receive, exchange, produce, and disseminate. And it says information that's true, verified, timely, in context on facts and general interest matters. All of that is specifically written in the text of the article in the Constitution. And based on that article, the sentence of the first and second instance protected the government and the state in terms of its right to true information. But when the constitutional case looked at the case in order to determine how to apply this article of the Constitutional Court reasons this out and says when there is a declaration of the principle of the freedom of expression approved by the Inter-American Commission, it says that to condition conditioning the information such as impartial or true is a principle that is incompatible with the right of the freedom of expression. So the court sees this tension in this Article 18 in this international norm and the international standards on freedom of expression. And as a basis of its decision, the Declaration of Principles is used by the court to interpret its own constitutional norm in terms of the right to having true information. Because you cannot understand the article in Constitution will a priori exclude protection of freedom of expression if information doesn't comply with the conditions, and those conditions should not be used as justifications to censor any type of speech. So you can see how an article in the Constitution that talks about the truthfulness as a condition to protect the right to disseminate information is interpreted in light of a declaration of freedom of expressions, even though that is not a treaty. Inter-American Commission is the body that's been authorized to interpret this treaty as the authority, but the Constitutional Court did not focus in the judicial value of the recommendations of the Inter-American Court or anything like that, but rather in the fact that the recommendations allow the court to interpret the norms of a constitution more favorably. And in that same sentence, the court uses the standards of faithful reporting so that they say that the information, the original information published by the newspaper wasn't going to be interpreted. It decided that in future cases, judges must also consider that if you reproduce information or declarations by a third party, you cannot be subject to a judgment of your truthfulness as long as you cite the source and unless you can prove that the expression was made maliciously or with the intent of damaging because you knew that the information was false. Or now, in terms of real malice, it's not really a standard for the Inter-American system. It originates in the New York Times versus Sullivan case of the Supreme Court of the US. So this standard of real malice has been expressly used by other courts in Argentina, Mexico, or Colombia. And of course, it has been used by the Inter-American Court of Human Rights. There's been some criticism in the way that the court in Ecuador incorporates real malice into our system, not just because of the difficulties to apply this standard in our context, but also because these norms are not the result of a democratic decision by our representative body. So in this specific case, I think it's obvious that the use of global standards was crucial to protect the right of expression. And I also think that the argument about there is no democratic validation to include our international standards is wrong because our constitution gave us that. perhaps we need to ask ourselves why these interpretations that are favorable to the international interpretation of human rights are so difficult, because if that's the basis of human dignity, we shouldn't have so much resistance, but the backlash is real. I have to wonder, perhaps this resistance is because courts have gone too far, or is it because this judicial dialogue has become a monologue? I think in this space, I know I don't have enough time, we were asked to share our personal opinion separately from our decisions. I personally think that we need to listen and deliberate on the reasons other courts have given you when you have to decide a similar case is beneficial, because as a result, you can have a common interpretation as to the content and importance of rights. And I think if all courts would do this, then we would have consensus and we would have more actors and more views when we have to interpret something, and we would have a shared interpretation of the rights. And this interpretation based on judicial dialogue in comparative or inter-American dialogue could, I think, lead us to have a better protection of these rights. As Judge Breyer says, we have a lot to learn from each other, and humans have to protect their rights two times, conventionally and constitutionally. And if judges would focus less on the hierarchy of the norms or of the text of the law, if we stop thinking about rights in their international dimension or constitutional as if they were isolated or separate, then we could maybe reinforce and increase the potential of constitutional justice to change reality and protect these rights. But the problem is that we don't always do this. Okay, I'll conclude. Judges don't always commit to reinforce protection of these rights. Frequently, unfortunately, we just use case law and comparative law just to reinforce these arguments. And I think if we use I don't think it's enough to just quote or cite other law. We should question the reasons in the case law that we're quoting. So we would have the best solutions that would be closer to what we want justice to be. And we would have to resist the idea that standards, just because they come from elsewhere, are better or more or are the last word. I think we need to rethink what makes a norm or a standard, what makes it what makes it so that we should respect it. I think we need to keep this dialogue so that we can interpret rights. We can't just consider that definite but they're constant construction together. And not only courts should be part of that dialogue. The dialogue shouldn't just be among judicial elite. This judicial dialogue should find ways for other actors, such as, for instance, journalists, can become part of this dialogue to build together what it means to have these global norms that protect us. So once again, I'm pleased about this initiative by the Global Freedom of Expression in Colombia, and I hope we can continue this dialogue and this exchange. Thank you very much.
Thank you very much, Vice President Salazar Marin, and thank you to all the speakers of the panel. This was really excellent and has given such good overview on specific questions of your jurisdiction, but also already raised several points where questions arise in general or are even coming up in an interrelated way. And we have now about 15 minutes for some questions and answers. We, unfortunately, Judge Anukam had to leave already, but we will have a little time among the 4 remaining speakers. And I welcome you all to also, in your answers to the questions I put out to react to the presentations you've heard. This is really a time where you can also interact to the presentation of each other. But I will start with a question to Justice Breyer. And you have spoken about the differences between many European jurisdictions and the United States on how hate speech is seen. And more generally, I think you have pointed out how difficult it can be to engage in comparative law, to look at other jurisdictions and their decisions, because they're ruling on different constitutional norms. And I want to ask a little more also based on the presentation of Justice Chandrachud, who spoke about the phenomenon of satire and such general phenomena that are not necessarily immediately rooted in legal norms. So I wonder, how much inspiration do you draw from the decisions and the reasoning of other courts, and how much do you view developments such as internet communication, maybe also the increasing dangers of hate speech that come with it? How much do you view those in dialogue with other jurisdictions, other high courts?
Right.
You have, yes. Yes, sorry, I should have said.
There are differences.
Take some time to respond.
There are differences, but underlying the differences are basic principles that people are free to speak and print in the press, and that's an essential element of democracy. So, but I think many of us, and less in some countries, more in others, can deal with the differences as long as they stick to the basic principle. And the problem for many courts is what I usually think of in Shakespeare, where Hotspur, who's the English general, meets Owen Glendower, who's a Welshman. I've written this a lot. And the Welsh general says, he's a Welshman, so he's a mystic. But he says, I can summon demons from the vasty deep. And Hotspur says, well, so can I. So can any man. But will they come when you do call for them? And I say that's the problem. It's easy to sit in an office and say that the government should not shoot journalists. That's an easy thing to do. Not so easy in some places. But once you do it, will people say, okay, we're going to punish them, or we're going to compensate the journalist's family, or we're going to see that it stops? That's the difficult thing in many places. And that requires the idea of the basic principle being there, but teaching it to enough people who aren't doctors and lawyers so that they see it is an essential part of a democratic process. It is an essential part of a government that takes them into account. It's an essential part of a democracy. That basic principle we all think. And our point, I think, in getting together is that we sense that, and we can discuss a few of the problems of getting that implemented in various places, and how could the others help.
Thank you very much, Justice Breyer. And I have a question to Justice Chandrachud. I was fascinated by how many references you brought up to other cases, to a case from Ecuador, to several other jurisdictions. And I have one question is, how much has this use of comparative law increased over time in your work? Is this something that is also a growing phenomenon, or has it been throughout the years that you work as a judge or that you're at the Indian Supreme Court? And can you maybe tell a little bit more about the practicalities of this? Comparative law is so challenging. One has to understand so much of the other legal context. So I would like to hear a little more.
Well, I think across the last 70 years and more that our Supreme Court has been functional since we gained independence, there's been a lot of dependence on comparative law. We began, say, with the American constitutional law. We, of course, draw from the common law traditions of the UK. And we've now expanded the reach not just to common law jurisdictions, but to civil law jurisdictions as well. And the reason for it is that increasingly technology has brought our societies so close together, because geographical or political boundaries really seem to be absolutely illusory in the context of the kind of technology that we all live our lives in. And I think particularly in the context of technology, the traditional divide between the civil law and the common law systems is slowly but very surely coming to an end, because that divide, I believe, is evaporating. And we've made extensive references to comparative law. For instance, there was a challenge to the biometric project of the government of India, where every citizen has to be his iris or her iris has to be photographed. Your thumb imprints have to be taken as a means of identity. And we drew extensively on jurisdictions such as, Germany and the European Court of Human Rights, the Inter-American Court of Human Rights. So that is, I think, a product of the kind of age in which we live. You asked me about satire before that, and I'd only say this: the satire is a powerful form of expression, because there's something about the imagery of satire which makes it so powerful. Now, when satire is used against the government, the judge's task is, I believe, a little easier, because you are protecting the right of the person who speaks to criticize government and use satire. It becomes more problematic when satire comes up against popular morals, against religious beliefs, because then satire comes against the intolerance in our societies. It's easier to defend satire versus the government. But when satire is pitted against the intolerance in societies and the growing tendency to homogenize societies into one particular frame, that is where I think the judge's role is very, very critical. And comparative law gives us some food for thought and some ideas on where we can stretch the limits of our law in our own societies.
Thank you very much. And I'm moving to Judge Farah McGregor with a question. And I found particularly interesting that you spoke about all the indirect restrictions on freedom of expression. And there we are in a very wide range of possibly affected areas. So I would like to ask a little more on that, and also ask in that regard how much you in your practical work as a judge have been looking at the decisions and reasoning of other courts, and whether in those indirect restrictions that really touch upon a lot of areas of law, you found that the comparative dialogue has been helpful or useful.
Muchas gracias.
Thank you very much for the question. Yes, okay. Thank you very much once again for the question. Of course, indeed, one of the main issues that the Inter-American Court has addressed is the issue of indirect restrictions. And this derives from the actual Inter-American Convention, Article 13. As Justice Breyer was saying, there are differences when it comes to the European Convention. In the Inter-American Convention, it should be compatible. This is not an absolute right, the freedom of expression, but it should be admissible, such restrictions, when they comply with the ends of a democratic society. And this restriction should be, one, should be legal, should be timely, necessary, and proportionate. And this is what we analyze in our courts case by case. And this text has been adopted by the respective Supreme and Constitutional Courts, and also regional human rights courts, so that the Inter-American Court and its convention in Article 13.3 says that we shall not restrict the right to freedom of expression through the indirect means, such as the abuse of official controls of particular works for paper, of journalists, of radio frequencies. This alludes to the case I was talking about earlier in my presentation, or devices that are used for the dissemination of information or any other media or means that would lead to the dissemination of opinions and information. The court, as such, part of the convention says, and it also analyzes what the European Court says, and its decisions are very rich in the matter. and its jurisprudence, in order to interpret the convention, it has established the Inter-American Commission on Human Rights. This is not a jurisdictional body, but it has established its standards, and such standards can be useful in order to interpret the convention. So in my experience, our courts uses sources that go beyond the Inter-American Convention in order to resolve and rule on cases when it comes to indirect violations, which is one of the issues that we are talking about today.
I have a last question to Vice President Salazar Marin. And you brought up the international law as an additional source in safeguarding freedom of expression. And I'm wondering, or I'd like to hear a little more on how you think about this relationship of constitutional interpretation of international law, maybe specifically how you relate to the Inter-American Court of Human Rights, and how this often is seen as a danger of interference also when there's a court ruling on international law and it has effects on the country. So in this interpretation of freedom of expression that touches upon so many political issues, how have you experienced the interaction between constitutional and international law?
Gracias, Dana, por la pregunta.
Thank you very much for the question. As I was saying, our own constitution is absolutely receptive when it comes to international law and human rights international law. Our own constitution mandates that we perceive and read our constitution, which has tons of article 444, but that's not the extent of the constitution. Beyond the text, we have a constitutional block where we incorporate all the international treaties and instruments. That means that as such, we cannot read the constitutional articles in isolation. We need to interpret them in conjunction with international jurisprudence and rulings from the Inter-American Court of Human Rights, for example, who interpret such treaties. This generates tension, of course, because on many occasions, the case that I was presenting earlier, there's a constitutional norm that maybe comes into conflict with international human rights norms. In our constitutional court, we try to see, not to see which one carries more weight. And I don't think that necessarily the Inter-American Court always has the last word. We do not believe this is necessarily the case, but we do believe that it's necessary to take into account its interpretation, to ponder such arguments. And if such arguments can provide more protection of these rights of our people, of individuals, then we apply this interpretation, regardless of the hierarchy of the sources. In many cases, what we do is try not to interpret such rights or norms as if they came into conflict with our law, but as a complement, as if they were complementary. I'll give you an example that it does not pertain to freedom of expression, but I think illustrates this. Our constitution, for instance, defines marriage as a marriage between a man and a woman. When our court ruled on equal marriage, is to link this marriage between man and a woman along with the ruling from the Inter-American Court and incorporated then same-sex marriage. So there's a much broader perception or interpretation. I don't think they conflict, but they complement each other. So we can actually provide better rights, a more favorable interpretation of these rights. This is not always as possible. There's a lot of reluctance, there's a lot of resistance towards this way of interpreting this source of the law. But I think we need to give better arguments. We need to not only use a source as if it was just the last word or it was the authority in the matter, but actually to provide arguments as to why this is a more favorable interpretation of these rights, and have this dialogue. I think in the Inter-American Court, while in some rulings and consultative opinions makes an effort to establish a dialogue with high courts, the respective high courts in Latin America, this effort is not always enough, because it doesn't feel like it's a dialogue between peers. It's like a monologue sometimes when it comes to the Inter-American courts. So we need to strengthen this dialogue as peers, as equals, and I think we can advance on this sphere as such.
At this point, I want to thank all the honorable judges for this very fruitful exchange. This has been an incredibly enriching session, and I feel this dialogue that you at the end also emphasized really took place for a moment here. So I want to thank you. And we have a 5-minute break before we'll move to the second session that will be moderated by Professor Luis Rubio Marin. Luis Rubio Marin is a full professor at the University of Sevilla and a part-time professor at the European University Institute with their School of Transitional Governance. And before we start the second session, however, we have 5 minutes of break, and thank you all again.
Good morning, good afternoon, good evening. Welcome to the second session of the conference Courts and Global Norms on Freedom of Expression, organized by Colombia Global Freedom of Expression and the World Leaders Forum. We will now address the challenges for the judicial protection of freedom of expression in the digital sphere. So, whether linked to the fact of the fast and global reach of the dissemination of expression, or to the fact that more and more people, and especially the young, rely on social media as means for mobilization, but also as sources of information, we observe certainly some opportunities, but also growing risks. Risks connected to misinformation campaigns, to the dissemination of hate speech and other forms of harmful speech, or to the public disclosure and manipulation of private data and information. Such risks are confronting us with unprecedented regulatory challenges for the protection of many fundamental rights, such as equality, freedom of expression, and privacy, among others, and the sustainability and health of democratic institutions. In particular, these regulatory challenges are connected to the inevitable public-private interface dimensions in the matter, to the transnational dimensions, and to the cultural implications which are necessarily present when it comes to drawing lines separating acceptable from harmful speech. In light of this, the question for us now is, how should judges deal with these challenges? How do they cope with the fact that their ordinary tools, the body of law and doctrine they have at their disposal, have been shaped in the pre-digital era? And to address this and more, we have today a truly distinguished panel of 3 honorable judges, which include Carmen Lucia Antunes Rocha, High Justice of the Supreme Court of Brazil. Welcome. Justice Darian Pavley, High Justice of the European Court of Human Rights, and Justice Alejandro Linares Cantillo, High Justice of the Colombian Constitutional Court. So the way we will proceed is as follows. I will allocate each judge 13 minutes roughly for the presentation. We ask them to stick to time because we would like to save a few extra minutes so that I can present the justices with a couple of questions actually coming from the student body that were passed on to me, and also maybe give them the opportunity, if they manage to fit that within 3 minutes altogether, to respond to something that they might wish to respond to in reaction to something one of their colleagues has covered in the presentation. So without further ado, I will now give the floor to Honorable Justice Carmen Lucia Antunes.
Bom dia a todos.
Good morning to all, the organizers of this important forum, excellent judges, ministers, and especially the students that are participating on this forum. And also Ruth, in the person of Ruth Ruben Marin, I'd like to thank in name of the Supreme Court of Brazil for this opportunity, for a forum organized for a debate that is so current and so important of such a challenging theme, such as the issue of freedom of expression in these times on new platforms, new ways to look at things. I'd like to first give you a few observations. All the challenges that are being presented to the contemporary and to constitutional judges. First is regarding freedom of expression. I'd like to present something about the Brazilian reality that is not unique, but it has its own unique characteristics like any other people. I'd like to make some remarks about this change in the constitutional law in a world that is changing, even in this notion of time and space, basically using this technology, not only constitutional law and basic fundamental rights, but also in the practice of constitutional judge dealing with this and the impact and use of these platforms and these democratic tools in the Brazilian process and the electoral processes, which forms the foundation of democracy, and are transformed due to these platforms and utilization by all citizens. I would like initially.
Sorry for interrupting you. Do you think you could add the other earpiece? Thank you so much.
Muito obrigada. Desculpem pelo, imagino que estivesse batendo aqui. Muito obrigada.
I apologize. Thank you very much. Initially, I would like to, as I said, talk about what we have happening in Brazil, because the impact of these platforms is going to be different historically. At this juncture, we are reflecting basically about the issue of the freedom of expression and the use of these digital platforms and their impact in the people's and institutional lives. We're still going through a pandemic period, also a political pandemic, as I call it. I'm sorry, the interpreter is having difficulty hearing what the judge is saying. We're doing our best. People were using more and more these technologies, public and private institutions, and even democratic institutions, and people in their living rooms. Suddenly, they have the notion that they can't talk anything about what they know or they don't know. And TV that disseminates live all the decisions of the Federal Supreme Court. People who didn't have the information, don't receive it, started to manifesting themselves.
Justice Antunes, I am really, truly sorry to interrupt you again, but it seems that we're still having some problems with hearing you and hence with translating. So what we're going to do is that we're going to interrupt you. Unfortunately, we're going to have Justice Pavli take the word, and then as soon as we fix your audio problems, we will revert to your presentation. We apologize.
Hello. I hope you can hear me okay. Hello to everyone. It is a real pleasure to be part of this forum. And I would like to start by thanking the organizers of this event, the Columbia University and the Global Freedom of Expression Program, with which I've had the pleasure to collaborate in different capacities for a number of years. In the time allocated, I will try to provide a brief summary of the main lines of case law of the European Court of Human Rights. I'm afraid it can only be telegraphic in the time possible, but I will do my best. Let me say a few words about the European Court of Human Rights in general terms. As you may know, the court has jurisdiction over 47 high contracting parties in the European space, broadly defined, which covers with a combined population of 830 million people, which I think gives the court one of the largest constituencies in the democratic world, perhaps second only to the Indian Supreme Court, which we had the pleasure to have a colleague present today as well. One of the themes of this fascinating discussion so far has been whether we can find common ground in interpreting freedom of expression in our very different, sometimes political and cultural contexts. And what I can say is that it is part of the very fabric of the jurisprudence of the European Court of Human Rights. One remarkable fact about it that is, despite this diversity, we have managed over the years to find much in common in interpreting the guarantees of free speech and other fundamental rights under the Convention. It has been one of the highlights of the day for me, especially. Many of the colleagues have already referred to the jurisprudence of the Strasbourg Court, but I think one highlight has been to listen to Justice Breyer reading out the second paragraph of Article 10 of the Convention and the permissible restrictions, limitations on the fundamental right of free speech. And while that list is there, and it is a rather long list, I think it has been part of the challenge and the task of this court to make sure that those restrictions are themselves interpreted in a limited fashion. As the court has said already in the early days of its jurisprudence, we have now about 5,000 cases interpreting Article 10. It is the fundamental guarantee of free speech that remains the rule, and that the exceptions cited in the second paragraph are just that, are exceptions to be interpreted narrowly in view of the principles of proportionality and necessity in a democratic society. And I emphasize that last part because it is a fil rouge that permeates the jurisprudence of the court. Turning now to the more specific topic, I'd like to focus on four areas, time permitting. One is on issues on intermediary liability. Secondly, on blocking of access to online content by government actors. Thirdly, what is known, at least in Europe, as the right to be forgotten. And finally, protection of journalistic confidentiality in the online environment. Intermediary liability, the question was put, how do the courts and the society as well deal with imposing traditional notions of publisher liability to these new online actors that in many ways operate in very different ways. It is worth noting that in Europe, we do not have an equivalent of Section 230 of the Communications Decency Act in the US, which grants rather categorical immunity to online operators. What we have in Europe is a system, as you may guess, a rather more middle of the way system of conditional immunity or a safe harbor for the operators. The central concept developed by the court in this area is whether third-party speech is manifestly illegal, and if that's the case, whether sufficiently prompt action has been taken by the operators to take such illegal content, manifestly illegal content down, especially where a complaint has been filed by an affected party. The leading case in this regard is Delphi versus Estonia, where which involved anti-Semitic speech and threats of violence, which were posted on a major commercial news portal. And the court decided that in that case, the portal could be held liable for not taking such content down quickly enough, and there had been no violation of Article 10. However, there is also a long line of cases. Delphi is the one that is most often cited, but there's a long line of cases starting with Mte and Index versus Hungary, where a third-party speech that was not considered to be manifestly illegal, for example, involving defamatory matters, and where there was relatively swift reaction by the operators of the website in relation to this third-party speech. In those circumstances, Article 10 would not permit the civil liability on the part of the operators. I think another interesting case that is worth mentioning is quite recent, is Bezaras and Levitskas versus Lithuania, where the court found that national prosecutors and courts as well had declined to pursue criminal prosecution. We've talked about hate speech quite a bit in our discussions so far. This was a case where national courts and prosecutors had failed to pursue criminal prosecution of Facebook users who had made strongly homophobic comments. And in those circumstances, the ECHR found that the decision not to prosecute in itself was vitiated, was marred by anti-gay bias, and that led to a violation of Article 8 of the Convention, which protects psychological integrity, as well as the prohibition on discrimination in Article 14 of the Convention. And finally, you may also find of interest a recent decision of the fifth section of the court in Sanchez versus France, which involved the liability of a politician for not taking down racist speech left by users on his Facebook profile. The second set of issues dealing with the blocking of access to content online by government actors, and in particular with a focus on what's known as collateral blocking and filtering. This is an area involving mostly Turkish and Russian cases, and here the court has treated blocking as a form of prior restraint and imposed a relatively high threshold, or a fairly high threshold, in fact. It requires a strict legal framework providing for blocking in limited cases. Secondly, effective judicial review, and finally, proportionality in the methods of blocking or filtering in order to minimize collateral harm. Moving on to the next set of issues on the right to be forgotten. This is increasingly recognized in Europe, including by the other European court, the European Court of Justice in Luxembourg, as the right to request the deletion, sort of the right to, in a way, to erase exposure to one's own negative history if the data is no longer relevant. And one of the leading cases from the court in this respect is Mlnw versus Germany, where the applicants had been convicted many years before for the murder of a famous actor, and then upon being released has sought an injunction against 3 media to remove online access to prior publications, which also mention them by name, and therefore seeking a right not to be permanently exposed to a spent conviction. And this was a case where the court fundamentally agreed with the assessment of the German courts, including the German Constitutional Court, and finding that there had been no violation of Article 8 where the German court of Article 8 of the Convention, right to private life, where the German courts had refused to grant these injunctions. The ECHR emphasized the importance of press archives and also the fact that the applicants had in recent years actively sought the limelight in efforts to get early release. However, it is worth mentioning that in a recent case, Hungary versus Belgium, which was decided by my own section 3 of the court, the court reached the opposite conclusion by finding that, by endorsing essentially the decision of Belgian courts to order anonymization of digital press archives in a case involving similar grounds, a spent criminal offense. I should note, however, that this case is not final and is currently pending. It has been referred to the Grand Chamber of the court, and so it will be taken up by the Grand Chamber, which is the highest judicial making body of the court. And let me also mention another case that is currently pending before the Grand Chamber, also by Section 3 of the court, Halle versus Luxembourg, which involves whistleblowing in the private sector, which is the first case of its nature decided by the court. Finally, let me turn to the question of protection of confidential journalistic materials. There is a long line of case law that includes very strong protections, I would argue, in terms of journalistic privilege. But in this particular case, Big Brother Watch versus United Kingdom, recently decided by the Grand Chamber, the court had to look at it in the context of what is known as mass surveillance or bulk surveillance in some contexts, which is operated by primarily the intelligence services in the online environment. And what the court decided in this case was that in order for this to be possible with respect to journalistic material protected by privilege, there had to be a specific authorization by an independent authority, both when journalists are targeted deliberately and when data is protected, is captured in an inadvertent fashion. So again, rather quite telegraphically, those were the four main areas that I wanted to touch upon. But of course, even though we've had dozens of cases touching on internet issues, there's still important questions related to freedom of expression in the online environment on which the court has not yet had an opportunity to deal with. These would include, for example, the liabilities, if any, potential liabilities of major global platforms with respect to speech that is harmful to others, as well as speech that is so harmful that can, or manipulation of information that can represent a major threat to a country's democracy. And finally, the question of what we would call, in terms of Strasbourg case law, whether there is a right of forum in relation to major platforms. In other words, what rights, if any, do we as users have when the platforms undertake actions that are adverse to our freedom of expression, like taking content down or blocking accounts. I think with this, I've probably used my time, but if there is interest in some of these areas that I mentioned towards the end of my presentation, I would be happy to come back to them during the Q&A session. Thank you.
Thank you so much, Justice Pavli, for your rich presentation and for sticking to time. And we're actually now going to give the floor to Alejandro Linares Cantillo. We're still, I think, struggling with the audio that would allow us to listen to the third speaker. Justice Cantillo, the floor is yours.
Thank you very much for the Colombia Freedom of Expression World Leaders Forum. And thank you very much to Catalina Botero, who invited me to this forum. I would like to share with you recent cases regarding freedom of expression in the digital area. And then after summarizing some of those cases, I would try to make some conclusions regarding the challenges that we face as judges in this area. The first case that I would like to share with you is a case of 2019 known as the Kikanieto case. Kikanieto is a Colombian influencer of 28 years old. She has 8 million followers, and she posted in YouTube a video expressing her views as a Christian, questioning LGBTQ, the LGBTQ community, dissenting with the homosexual relationships, and showing some sort of a gender bias in this regard. After this video in YouTube was posted, then a newspaper blog known as Las Igualadas posted another YouTube video entitled Kikanieto hates gays and lesbians despite denying it. And the defendant is this post by Las Igualadas, owned by a newspaper, by El Espectador, and then the plaintiff is Kikanieto. She filed a claim, a constitutional claim, saying that the video on YouTube violated its reputation, its good name and honor. The case went to the court. The court had to look at the two videos, which was really interesting. And the holding of the court was that the video by the newspaper did not exceed the limits of the right of freedom of expression. And therefore, that the second video did not defame the plaintiff. Interesting in the analysis of the court was, first of all, the application of the freedom of expression right between a newspaper and an influencer when the influencer has more followers than the newspaper. So the court did some sort of a balance between the number of followers of each expression, and said that that in this particular case, the influencer could have replied directly to the other video without recurring to the constitutional judge. That's very important in the sense that this type of fights or differences of opinion in the context of the digital platforms has become an interesting issue, as we will see. There are more horizontal application of fundamental rights between private actors rather than between the state and a private citizen. In this case, it is also important that the court distinguished between freedom of information and freedom of opinion, indicating that freedom of information is subject to truth and impartiality, whereas in terms of opinion, everybody has the right to hold opinions without interference from the constitutional judges. The court also said in this interesting case that historically discriminated groups such as the LGBTQ community should have a higher protection under constitutional law and should be protected from this type of defamatory speech. The second case also involves fact patterns related to an interchange in Facebook and YouTube and Google between private persons. In this case, is what I would call horizontal conflicts. That is, two private parties fighting for protecting their honor or their good name using platforms. And the court, in this case, also of 2019, analyzed the potential excesses of freedom of expression on the internet. And the court said that those statements have to have constitutional relevance in order to be assumed by the constitutional judges. And the fact that there are some public recognition and significant audience on the part of the different actors that interchange opinions or information on the internet will, if they have impact on the public concern, they might trigger the intervention of the constitutional judge. But the interesting thing here is that what the court says is that the repetition or the repetitiveness of the statements and the offensiveness of the statements would or might trigger an abuse of the freedom of expression right, and therefore that should trigger at the same time the intervention of a constitutional judge. It is interesting that the court has been very reluctant to intervene in these horizontal exchanges of opinions. Besides, the court, as Justice Breyer had indicated before, our court, when there is a balancing of rights between freedom of expression and other types of rights, such as good name or reputation, uses the so-called, the well-known strict proportionality test. And so the court used this proportionality test to solve these cases. In the end, the court decided not to intervene. However, it said that the repetition and the offensiveness of the statements might trigger its intervention. Besides, the court, in an obiter dictum, studied the liability of intermediaries, indicating that social media platforms and search engines bear no liability whatsoever for the content posted by the users, but said that in occasions, if there is a court order to remove the content that is posted in a platform, the search engine or the media platform has to comply with that order. Finally, there's another case of 2020 in which there is also these cases of interpersonal conflicts. And my view of this case, this is ruling T031 of 2020. There is also in this case interpersonal conflicts that are exacerbated by the use of social media. And the court has indicated that this type of horizontal interpersonal conflicts, that is conflicts between individuals with no notoriety, that are not public officials, should not lead to constitutional relevance and therefore should not trigger the intervention of the constitutional judges. Going to my conclusions from these three recent cases regarding horizontal issues of freedom of expression. Number one, the Constitutional Court traditionally has emphasized that the freedom of expression is essential in a liberal democracy. That's part of the jurisprudence of the court, but also, as was indicated by Judge Ferrer, the court also follows the jurisprudence of the Inter-American Court of Human Rights and the European Court of Human Rights, and assumes that the right of freedom of expression is protected not only in the Colombian constitution, but also is protected by all international and regional human rights instruments that are part of our constitution. As was indicated by Daniela, we have a block of constitutionality in Colombia, so the international human rights treaties are part of our constitution. Another, the challenges that we have is, first of all, how to deal with the horizontal effects of freedom of expression. In other words, if there are two private actors, how should the constitutional judge intervene? And here we believe that if there is a high disproportion in power or in number of followers, there should be some intervention of the constitutional judge applying a balancing test using the proportionality test that has been used. There are problems regarding the liability of intermediaries. We have to focus on that. There is also some problems of territorial jurisdiction. For example, Google, Facebook, Twitter, those platforms or those companies do not have their domicile is not in Colombia. So when we order a certain type of removal of contents, the question is whether or not there would be voluntary compliance with our orders that might have an extraterritorial effect. So this trans-jurisdictional communication is not easy. And the other areas in which we should see our challenges is in the application of contract law, because most, for example, Facebook and Twitter have terms of service. So when you want to remove contents, you have to exhaust remedies under the contract before going to a constitutional judge. There is some cases talk about addition contracts, that is contracts that are not negotiated between the parties. And last but not least, we are thinking about applying antitrust regulation when there is a high difference between the private parties that are in conflicts in the digital era. Those are my reflections. It's too little time, but I'm happy to undertake certain questions. And thanks again to Catalina for providing me this opportunity.
Thank you, Justice. I think this was an extraordinary, rich presentation showing some of the fascinating questions when we take the Drittwirkung and the horizontal effects and we apply it to scenarios where new forms of private power are affirming themselves versus traditional forms of private power that we were used to seeing limited by these horizontal doctrines' effect. And many of the pending issues that you highlight regarding liability issues and the intermingling of public and private law, which is inevitably part of the equation. I think we're now ready, finally, to listen to our Justice Carmen Luisa Antunes. The floor is yours.
Mais uma vez, cumprimento os organizadores deste importante.
Again, I would like to thank all the organizers, and I apologize for the inconvenience of issues that are inherent to these platforms, not only in the legal but in technological area. Sometimes we have a good or bad performance. In this case, I apologize. I'd like, besides greeting and thanking the Professor Luz Ruber for this opportunity to be here, I'd like to, in the first make a few observations in three items. Number one, the structure of freedom of expression within Brazilian democracy and the recent Brazilian experience, because differently from other countries, discussing this issue. In Brazil, we are under a constitution that came about after many years of an authoritarian regime in which we had a total lack of freedoms and freedom of expression. And that's why that within a new constitution translated a new moment that the Brazilian society and citizens to express themselves didn't have a voice before. Whoever had went through this knows how much it hurts to have your voice suppressed. So we have a lot of care to the freedom of expression, because this is a still open wound of my generation that had to be had their freedom of expression repressed, and it's important. Brazil has this historical data and this history of living without freedom of expression, and people disappeared, they were tortured, they were even killed to exercise this right. So I would like to briefly reflect on this new reality of democracy with the news platforms and the private and public spaces, public and private institutions. This affects on one side the right to intimacy, honor, and privacy of people. For some people, they think they have so much rights that they think that they can say whatever they want in social media and freedom of expression. Our Supreme Court has been dealing with this for very directly. I'd like to make some. Brazilian democracy is representative, but our elections are completely electronic. They depend, therefore, on these platforms, of these technologies. We are still developing, or have been developing this for 2 decades, to get to completely, fully electronic elections. Therefore, these platforms, in our case, an institutional data of presenting and administer elections, and everything through electronic platforms, and also institutionally through these platforms. So I'd like to very quickly just situate freedom of expression within the Brazilian Constitution and the Supreme Brazilian Court as a theme that is important and very prominent. Our Constitution just completed 33 years in effect, and these constitutionalizations, as I said, appeared after a very hard period of authoritarianism, when you didn't have any freedom of expression, whether the private citizen or some of our greatest educators, thinkers, artists had to leave the country. Some were exiled, others had no condition to live like that. There was a previous censorship, even to songs that could not be released. So there was no form of expression that was exposed without the state, or the authoritarian state conducted the censorship. That branded my generation before mine and my generation of law students, that to listen to certain songs by Caetano Veloso, Gilberto Gil, Chico Buarque, I had to hide, and that was hidden, so you could appreciate art. So freedom of expression in the reconstitutionalization of the Brazilian state is a very it comes with a very lot of strength. We conquered our freedom, saying that we wanted to speak, to see in politics, in society. We didn't want to, as citizens, and especially especially us women, we didn't want to be invisible anymore in a fake democracy that only had a name in the text. Therefore, the 1988 Constitution, that is the one in effect, emphasized, and there's a disposition between the basic rights that guarantees freedom of expression and prohibits anonymity, but says that anybody can express themselves free from any action from the state. And there's even this position in the Constitution that forbids expressly any kind of censorship. This is something that, as a constitutional judges, we have in consideration to judge, even, for instance, cases in a platform, in a social network, somebody expresses themselves regarding another or criticizes public or private institutions or people that are acting in these spaces, public or private. This is not common in constitutions. That has an impact in our decisions because we don't want neither to go back to censorship of freedom of expression. And as a constitutional judge, I've been learning to explicit and interpret well, which for us, what for us is freedom of expression is the expression as a manifestation of the exercise or an exercise of freedom. But I have been learning with these new platforms that expression could be a weapon. When you commit a crime with another person, and we have today we have a what I call a digital Western. Norms, policies regarding freedom of expression are being utilized by people who practice crimes in social networks and these platforms, exactly in detriment of the rights of others. In the Brazilian case, as I said, when you have a freedom of expression, there was a conquest of 2 or 3 generations, so we could have access. That means that as constitutional judges, we have to weigh what is somebody's freedom of expression against censorship exerted over others that cannot be admitted in the Brazilian system. And very briefly, I would say that this Supreme Court has been put to action several times, whether by people who think they have been offended in their privacy by the exercise of these social networks, whether because for our elections, as I said, the candidacies are presented and programs presented by social media and not in person as it was used to be, because we want to ensure that everybody has the right to informative self-determination, people who don't know what's going on, and we have a test of civic information to have to exercise your political rights. But on the other hand, we have in many cases abuses even against the democratic institutions. Democracy has this feature that's different from any authoritarian regime. It does not extinguish, it does not eliminate who is against it. It lets others manifest themselves or express themselves. It doesn't let that compromise the democratic process. That has been coming to the attention of the Supreme Court of the Brazil, when many people, citizens themselves, have been acting against institutions, even against to offend democracy or risk the democratic process. Been saying in the our Supreme Court, number one, the freedom of expression or as expression of freedom, establish some parameters beyond which it's not the freedom that is being exercised, but the use of these platforms in detriment of our institutions and putting in risk democracy itself. In the last elections last year, 2020, we called the providers of these networks to the court so we could establish together the standards and behaviors that they would, at the end of the day, be liable for. So we have in Brazil the assurances that elections will be held with equal access by all citizens. Of course, some people have better access to others. They can introduce certain algorithms and false ideas. On the other side, we have a system to control social media during the electoral period or period of elections, so that we can have assurance that all candidates and all the electors have equal conditions of access to social media and true information. The federal system or the federal government established an organ to control veracity of information that is disseminated via social media. So in our site of the Supreme Court, there is a section about everything that has to do with sentences pronounced by Brazilian judges that could be considered fake, could be corrected in the site of the Supreme Court itself, so the citizens can know what's fact and what's fake. But I had no doubt that my biggest challenge as a constitutional judge, and next year we have presidential elections in Brazil as a federal judge. 3 ministers of the Supreme are also in the Supreme Electoral Court, and our biggest challenge we will have in the near future will have to be have some kind of proportionality with the risks to this freedom to on one side and democratic guarantee to a full manifestation by the citizen without any embargo to the democratic and elections process in the Brazilian state. As I said, it's a recent construction. These are only 3 decades that we've been ensuring freedom, but our wounds are still open. However, we know as constitutional judges, we know there is no arithmetics. We can't use, you can't level mathematically what is freedom of a person to expose their ideas and be against what they need to be changed, and it guarantees that their expression will only be considered constitutionally legitimate if they don't eliminate or compromise the freedom of another, but especially that it doesn't risk the Brazilian democracy. I think that's the main issue. There's been a lot of growth in the access to these to the social media, especially during this pandemic. But as I say, our COVID pandemic cannot become a digital political pandemic without norms that are established so that people can be assured of their right to express themselves, but also to have their individuality respected, that this does not take place without have a judicial power over these matters. I would like to thank the opportunity again to be here, Professor Rubio, all the professors, and again, I apologize for the initial problems for the misuse of this platform. Thank you very much.
Thank you, Honorable Justice. It was a very interesting and quite illuminating account of the active role that courts can take when they see social media becoming the domain, the political forum, and the ways in which this can threaten democracy. So now I have the pleasure to give the floor back to you. And what I thought I would do is I would share with you 2 questions that have come from the students, and I will let you choose between addressing, those questions, or if you wish, reacting to something that you have heard your colleagues talk about that you think is particularly interesting and or disturbing. Let me briefly refer to the questions sent by the students. There were two. The first one is the following. When drawing the line between acceptable and harmful speech, cultural value judgments seem inevitable. How do you navigate the challenge of drawing such lines in multicultural and multi-religious societies? And what to make of the fact that in the digital era, expression almost inevitably has a transnational reach? So that is the first question. Second question is, what is the role of judges in regulating social private media companies in order to end hate speech online while still maintaining users' freedom of speech? So each of you has 3 minutes. I will give Judge Darian Pavli the word first, react to these questions or to anything else that you've listened to.
Thank you. Thank you very much. Maybe I'll touch upon an aspect of the second question, which is the overall regulation of the private media companies and their impact, both at the individual level, at the rights of individuals who may be harmed by the speech of others, but also at the level of the overall health of our democracies. I think this also touches upon the point that was raised quite a few times by the colleagues, and in particular by Justice Linares Cantilla, which is the horizontal effect. And the first point I would make is that this horizontal effect, it's quite familiar to those of us dealing with these issues in the European context, as well as the jurisprudence of the court. The terminology we use as an international court is that of positive obligations on states, and the court has identified many kinds of positive obligations in the balancing that is required between free speech and other values. For example, the court has recognized that there's a positive obligation on the states to create an environment that is not hostile to journalism, for example, to take steps to protect them from violence. But of course, the same can be said in the balancing that is done between free speech and privacy or reputation that most of the time occurs at the horizontal level. And to be honest, it is probably not very different from what, for example, the US Supreme Court has done in New York Times versus Sullivan, of course, through the angle of Congress shall make no law, but ultimately affecting and modulating the balance between the rights of public officials and those of journalists. With respect to the platforms, I think that this is one of the big unresolved questions of our era. What rights do we have? We know that they serve as gateways to public discourse, to a very important chunk, increasingly important chunk of public discourse. These affects ordinary individuals, but it also involves people vested with public power. And I think this was most evident in the recent, some time ago, the decision, for example, of Facebook and Twitter to block the accounts of the former president, the then sitting president of the United States. So that is some formidable power. I don't want to suggest in any way that there was a decision that was taken lightly, and there is a long decision of the Facebook Oversight Board, which includes some very widely acknowledged experts. But I think it is an illustration of how much there is at stake, that this is a question that cannot be left solely to questions of private law, of contract law, in terms of service and community standards, and that sooner or later it is a question that, at least to some extent, needs to become justiciable and subject to the judicial review, because it is simply too important to be left to questions of contract law. Thank you.
Thank you very much, Justice. Justice Alejandro Linares.
I think I will also take the second question, because this is something that I've been thinking about, which is how to find solutions to these new issues brought by the internet, because internet increases the effective opportunities for all people to communicate their views nationally and internationally, and that brings us to take from the existing law ideas or institutions such as the horizontal effects among private actors. The same goes with the balancing interest through the proportionality analysis, which is the approach that uses the court to solve these issues. But my view is that the solutions to some of these new issues might simply be the application of the existing rules on freedom of expression without a significant modification, but of course with certain adjustments to adjust or to address certain emerging problems of the freedom of expression. I believe that the platforms allow us to have to express our views, but that requires certain limits using the balancing approach. But the issue with private actors with a lot of power could be one issue would be self-regulation, or one solution would be self-regulation, as Facebook has done with its panel in which Catalina is a member, or also apply the theory of adhesion contracts, that is, contracts that are not negotiated, in which there is one part with more power than the other part, and then in the interpretation of those contracts, you would favor the party that has less power. And even in this context, there is a higher importance for the right to privacy. Finally, the difficulty arises from the enforcement of decisions at the multinational level. In other words, a decision by a court in Colombia that has to be implemented or enforced in the United States, it means that there should be voluntary compliance, because I see it very difficult to have the enforcement of a constitutional judgment in another part of the world.
Thank you, Justice. And now, your final minutes, Justice Antunes Rocha.
Obrigada mais uma vez pela palavra. Eu também.
Thank you once again. I would like to also say something about the second question. I would like to call your attention as my own. First, we have the relationship between people that are one side, one person who expresses the other person that thinks that has been impacted with that.
On the other side, by people that could be affected by it, when the judiciary power cannot respond to that
with certainty,
the celerity that would be necessary.
So
and
these are the circumstances that while the executive power
the executive acts for the present perspectives for the future, the legislative makes
talks about the future.
Policies for the future.
At the judiciary level, we talk about the past. Something already happened back then. There was already a manifestation in the social media, and someone was already insulted and impacted on what we act in this velocity of social media. Not always has they have their efficient. the judicial response. Sometimes the news, there's another approach in the social media. Judiciary is parsimonious because it has to deal with the past, but the past is too close, and we don't have that velocity. So this is something I would like to include here, is that we are talking about also about the validity of the effects of the social media. But I was a reporter at the Supreme Court some months ago about a request made from a citizen who asked me to determine that the President of the Republic excluded him from the Twitter to readmit him, because the President of Brazil, as in other countries, uses that as a manifestation, a political manifestation, publicly, which is, making public his decisions at the palace where he lives, and he runs the country. Now, this is I have the right to be there and determine that the president be re-included. If he uses that space as a common citizen is one thing, but also it's as if I was a judge using the Twitter to regarding my instructions, I would have to include that when everybody has the right to be there. That's a decision that is isolated yet here, but there were other cases that we didn't have plenary sessions on those. But what is horizontal and what is constitutional? What is vertical in the matters of platforms? And the first concern that I have is that the greatest struggle in my life is to fight for equality. I had a very modest childhood, and I was able to go to school. My father was able to maintain me as I went through law school, so I had the opportunity to reach the Supreme Court of this country. I don't want the children and Brazilians do not have the digital education, so they don't have equal rights. And I don't want this pandemic to see women, to have them lock them in their homes without access to media, and there are aggressors who are leaving to them, and she's not able to denounce these aggressions because she has no access to those digital means. So we're talking about the judicial power at the supreme level, but also at the first level judge, because we had to be distanced from each other because of the pandemic, but the judge talks to the woman that has been attacked, and she has and the cell phone is held by the aggressor, actually, because what assurance am I given to equality? I don't want to be 30 years from now that the judges that are in my place have to face this again, to deal with new technologies that were not coming to promote the equality of people, at least at the existential level. And I think that, as Judge Alessandro already said, technology has come to also provide information, but also to make things more equal. And I thank everybody else. Thank you to everybody.
Thank you for bringing up the digital gap, which is something we didn't have time to touch upon, but it is, of course, at the core of our concerns. And I think our time is up. I want to thank our honorable judges.
Acho que já se acabou o tempo. Gostaria de agradecer Suas Excelências por compartilhar suas experiências na proteção da liberdade de expressão na esfera digital. Tivemos mais.
From Catalina Botero, from Columbia University, from Colombia Freedom of Expression, and co-chair of the Facebook and Instagram's Oversight Board. Catalina?
Thank you very much, Professor Rubio Marin. It has been a real honor for us at Columbia Global Freedom of Expression Initiative to host this conference. I want to thank the honorable justices for their extraordinary presentations. They have generously helped us understand how they face current freedom of expression challenges. I would like to thank also our two distinguished moderators, Professor Dana Schmaltz and Professor Ruth Rubio Marin. My deep gratitude to Professor Roberto Saba for his wonderful contribution to this meeting. And I especially would like to thank the Columbia Global Freedom of Expression team, Barbara Schreiber and Olive Johnson, for their invaluable support in organizing this conference. Our gratitude also to the World Leaders Forum for co-hosting this event, and to UNESCO for their huge support. And of course, to more than 500 attendants who have joined us today from all around the world. Nowadays, justices are one of the most important guarantees of freedom of expression. That's why I would like to close this conference by paying tribute to those judges who with courage and wisdom have protected our rights from the authoritarian impulses unfortunately increasingly widespread. They deserved our gratitude. Again, muchas gracias, muito obrigada. Thank you very much, all of you, for joining us today, and I hope we will meet again soon at another conference of the Columbia Global Freedom of Expression Initiative. Thank you very much.